Hello everyone. Today, we are going to learn about limited of auditors and quality control. So, let's start with liability of auditor under Companies Act. When auditor violate the Companies Act, the auditor shall be penalized and held liable according to what offense he had done. I will show to you few of the liability of auditor under Companies Act, which are: first, misappropriation of client's money or property. When the auditor has misapplied the client's money, he shall be liable to pay the money or property of the client. Moreover, the courts has the authority to forces the auditor to pay for the money or property. Second, when auditor violate the law regarding the qualification of an individual to be appointed as company auditor, he shall be penalized with a fine not exceeding to 100,000 ringgit. Next, an auditor shall be penalized when he failed to circulate the financial statement that includes signed statement from the auditor to the company's member. The auditor shall be penalized with fine not exceeding 20,000 ringgit. However, if auditor still continue to do such act even after had been convicted, he shall be fined 100,000 ringgit for each day, starting from the day he continued to make the offense. Lastly, breach of trust or duty imposed by law in the auditor's work performance which result to damages and losses towards the audited company. Result in the extent where the liquidator may bring the auditor name as an officer of the company to the court.
Liability under common law. Case law developed over time by judges who issue legal opinion when deciding a case. The legal principle announced then become precedent for judges deciding similar case in future. Under the common law, auditor held liable to client, for breach of contract, negligence and fraud, while auditor held liable to third party, for negligence and fraud. The difference between client and third parties is, client has an agreement with an auditor, whereas third parties have no agreement with the auditor but they use information from audit report for making decision. Liability to clients. When the auditor accepts appointment, he actually enters into a contract with client which then indirectly impose certain obligation on him. Breach of contract. For example, the auditor's failure to complete the job as stated in the engagement letter. The auditor is also required to perform the professional service with due care, same degree of skill, knowledge and judgment with the other members of the profession. Some examples of third parties are bankers, government and investor. Action against the auditors for negligence can be brought by the client and third party. However, the plaintiff must prove the followings. Duty of care. The auditor owed a duty of due care to the plaintiff. Breach of duty of care. The auditor has failed to act in accordance with due care. The standard of care is that of the reasonable skill and care of another person carrying the assignment. Casual relationship. There is casual relationship or connection between the auditor's negligence and the plaintiff damage. Damage. The plaintiff suffered actual loss or damage. Example of case for duty of care is the case of Chandler v. Crane, Christmas and Company, 1951. The plaintiff invested in a company based on audited accounts prepared by the auditor, negligently prepared. Company subsequently became insolvent. Mr. Chandler sued the auditor. Auditors did not deny their negligence and they were aware that the account was used by plaintiff to make investment decision. It was held by majority of the Court of Appeal in England that in absence of a contractual relationship between the parties, the auditor did not owe a duty of care to the plaintiff. Under UK common law, professional accountant would not be held liable to a party outside the contractual or fiduciary relationship based on doctrine of privity of contract.
Breach of contract and negligence. An auditor is responsible to the client in auditing due to the contractual relationships between them. An auditor also must perform his duties with responsibilities, skilled and competent. Breach of contract means one or both parties are failed in fulfilling the requirement of the contract. while negligence means careless or unintentionally actions by an auditor which he failed to adopt the professional behavior in auditing. If an auditor is breaching his contract, clients and third parties will be the one who can bring an action towards them. In what circumstances where negligence can happen? Negligence can happen where there is a violation of confidentiality, failed to discover any errors and failed to act according to the laws and regulations. What is the effect when the circumstances arises? There will be a lawsuit against the auditor for negligence and they will be responsible to suffer any losses occurs.
Limited liability. Auditors are permitted to limit their liability to a company by contract. This is a liability limitation agreement, LLA. The main purpose of the contracts is intended for auditors so that they will not suffer extreme damage. An LLA cover, first, negligence, second, default, third, breach of duty or breach of trust. An LLA must be authorized by company members. Must specify and be limited to one financial year's audit. Must limit liability to not less than a fair and reasonable amount. Regard to the auditor responsibilities, nature and purpose of the auditor and the professional standards expected from the auditors. Role of Auditing Oversight Board. What is Auditing Oversight Board? Auditing Oversight Board is to provide independent audit oversight over public interest entities to ensure our regulatory framework for auditors is on par with international standards. The establishment of AOB are to have an oversight system independent of auditors, to ensure only fit and proper persons allowed to audit financial statements, to modernized appeal process, to have a broad range of sanctions. What are the responsibilities of AOB? Part 1.I.A. of the SCA provides that the AOB, in assisting the Securities Commission Amendment Act in discharging its audit oversight function, is responsible to, first, implement policies and programs in ensuring effective audit oversight system in Malaysia. Second, direct the MIA to adopt the auditing and ethical standards. Third, conducting inspection to assess the compliance of auditing and standards. Lastly, impose appropriate sanctions against registered auditors who fail to comply with standards. What is the objective of quality control? It is to provide guidance regarding a firm's responsibilities for its system of quality control for audits and reviews of historical financial information. There are 6 elements of quality control. Elements of a firm's system quality control addressed in ISQC 1 comprise of, firstly, leadership responsibilities for quality within the firm. Firm shall establish policies and procedures designed to promote internal culture, recognizing that quality is essential in performing engagements. For example, rewarding high-quality work and support quality control. Secondly, ethical requirement. It is to promote reasonable assurance, comply with fundamental principle of ethics and maintain independence. Thirdly, acceptance and continuance of clients and engagements. Policies and procedures provide the firm with reasonable assurance when clients' management lacks integrity is minimized. Fourth, human resources, that is the hiring process, which means hired those with the appropriate characteristics of competency. Fifth, engagement performance, which means the work performed meets applicable professional standards and regulatory requirements. And the last one is monitoring. Policies and procedures established by the firm is to make sure elements of quality control are being effectively applied.